Raven Priamores from the Appellate Division of the Public Defenders Conference here on behalf of the appellant, Jeffrey Wayne Dean. May I reserve 4 minutes for rebuttal? I will spend my time here discussing the sufficiency arguments raised in Mr. Dean's principal brief, but I'm more than happy to address any questions relating to sentencing that the panel may have. The evidence presented at trial was insufficient to sustain Mr. Dean's convictions for aggravated burglary and felon in possession of a firearm. The sufficiency argument for both convictions is grounded in the state's failure to prove that Mr. Dean had the culpable mental state required for those convictions. Relating to the aggravated burglary offense, the state was required to prove that Mr. Dean entered the residence with the intent of committing a theft. As a matter of law, the proof presented at trial does not support that.
Let me ask you a question. When you're looking at the sufficiency issue about theft, you can look at the circumstantial evidence to also support the fact that a crime was being committed, or at least was being prepared to be committed. Is that correct?
Sure.
And in this particular case, you have a number of items that have been pulled out and placed on the bed and obviously moved from where they were and then placed on the bed, which the jury heard about. Doesn't that go to circumstantial evidence of his intent to steal?
Well, certainly that's part of the proof that's in the record that the jury could consider in determining whether or not Mr. Dean was guilty of the offense of aggravated burglary. But I submit that there was also proof of intoxication that was fairly submitted at trial as well for the jury to consider. And there's some disagreement about what proof of intoxication was submitted at trial versus sentencing.
Well, what is in the record at trial on that?
So we have proof from 2 state witnesses. Officer Ridgely, he was one of the first officers to arrive at the residence, and he gave a candid explanation to the homeowners that he thought the reasons for Mr. Dean's unusual behavior was drugs. This is also captured on Officer Ridgely's body camera footage that was also introduced at trial. Then we have Officer...
What was introduced on the body cam? Because we haven't looked at that yet. What, just his statement, or is there evidence? Are you arguing there's evidence on the body cam footage that the jury would have seen that he was intoxicated, the defendant, that is?
Yeah, well, both. So you have that statement specifically by Officer Ridgely, and then you also have, you could see what the officers saw when they arrived inside the residence and could observe Mr. Dean's demeanor for themselves. So
my follow-up question is, the jury saw all that, and did they not make a determination? They made the credibility finding.
Well, I guess it goes a little bit further than that. Obviously, I understand that voluntary intoxication is not a defense to criminal prosecution, but it is relevant in determining whether someone has the mental capacity to reach the culpable mental state required for the offense. And I just don't think that we have that here. And I think as a matter of law, when we look at it, we have to look at all of the proof of intoxication that was submitted, as well as Mr. Dean's unusual behavior once he entered the residence. I think coupled with that, we just don't have that someone entered the residence with the intent to commit a theft. So Officer Wright also testified at trial that he suspected Mr. Dean was under the influence of some intoxicant at the time of the offense. He conducted the interrogation video. He conducted the interrogation of Mr. Dean, and that video is also introduced. During the interrogation, Mr. Dean gave the explanation that he thought he had permission to enter the residence from unknown persons standing outside. Obviously, these persons were never identified.
They told him to tear the door out, basically, to get in?
I wouldn't.
And that seems like a credibility issue that the jury weighed and made a determination that they didn't believe him.
Well, I guess what I'm arguing here is a little bit different from credibility versus proof of intoxication, up to the point of whether someone had the mental capacity to have the conscious objective or desire to commit a theft upon entry. I guess you could look at that as a credibility determination, but you also could look at it as proof of intoxication.
Well, obviously, the jury considered all this. This was all being placed before the jury. Jury could have also looked at it and thought that he was just trying to fabricate things to make an excuse for the police, because, you know, they looked at the totality of the circumstances and obviously didn't believe that this was just some mistake. They believed, apparently from their verdict, that the defendant intended to commit a theft after breaking into this house, even with all this other stuff that you're talking about that they heard. So doesn't that carry the day when the jury makes those kind of determinations based on the evidence that was in front of them?
I think we have to go a step further. I don't think the fact that the jury found Mr. Dean guilty of aggravated burglary means that the jury didn't believe that Mr. Dean was intoxicated or maybe even suffering from hallucinations. I think we really have to look at Mr. Dean's behavior after he entered the residence. So my argument relating to the case law surrounding aggravated burglary, when you have someone breaching the barrier to someone's home, case law suggests that at that point we have established aggravated burglary if there is intent to enter with the intent to commit a theft.
Now, he went through these people's drawers. The pistol specifically was in a drawer in a zipped up case, and it was removed from that drawer. I think it was on the floor outside the case. I mean, obviously, he's going through things.
Yeah.
I mean,
so there's obviously, lots of facts here. And I would just point the court's attention to some of the other facts in the record that really demonstrates Mr. Dean's unusual behavior that supports that he was operating under the mistaken belief that he had permission to enter this residence. So once he entered the residence, he scattered his belongings in several places in the home. He then picked up the homeowner's wind chimes off the kitchen counter. And instead of putting it in a bag outside or displaying any intent to carry it away or anything belonging to the homeowners for that matter, he hung the wind chimes on the front porch, re-entered the residence, ate a Pop-Tart, rifled through the homeowner's closets and drawers looking for clean clothes to wear after his shower, which is all kind of in a line with this mistaken belief that he thought he had permission to enter.
But, I mean, doesn't it also, it could also show that he broke in, he was hungry, he wanted to get clean and have clean clothes, and he was just gonna take them from that home.
I guess that's one way to look at it, but I just think that Mr. Dean was in the presence of numerous valuable items, right? Things that you would typically see in a home. And majority of all of that was undisturbed. Everything that Mr. Dean rifled through in this residence related to his mistaken belief that he could find clean clothes to wear after his shower.
Well, he was on foot, wasn't he? I mean, I'm not sure it's in the record that he was homeless, but it sounds like he didn't drive up there where he had a pickup truck and, he was gonna load up all the high-end appliances and take them off. I mean, it's not reasonable, is it, to think that he was gonna take some of those large things with him if he was on foot?
I mean, but there are other things that are not necessarily as large that others might think are just as valuable.
Like a gun?
Like a gun, yeah, exactly.
Well, I mean, I guess before I get to the gun part, I would like to point out a little bit more. So you also had, after he rifled through all of these belongings in the home, right? He then chose an outfit and hung it outside of the shower that he intended to put on afterwards. This, again, is just consistent with his mistaken belief that he had permission to enter.
Does it also indicate that he just was going to take it? I mean, this idea that he had permission and he was, I mean, it also, the jury could look at this and say, he was just looking for clothes to put on and he found something he liked and he was going to put it on and take it. I mean, there's just as much, value in that than there is in saying that, he was mistaken about coming in the house and thought he had permission.
Sure. But I guess I just want to point this court back to the requirement under the aggravated burglary statute is that the state has to prove that someone entered with the intent to commit the theft. It's not sufficient to find that once he entered the home, then he developed the intent to commit the theft. The state had to prove that intent beforehand, which kind of goes to my point that I was trying to make earlier, that if there was sufficient proof that he entered with the intent to commit a theft, the aggravated burglary would have been complete the moment he gained entry into the home. And I think his unusual behavior once he entered into the home really aligns with his mistaken belief and does not demonstrate that he had that intent to commit a theft before he entered. And also, just for clarity, Mr. Dean is not requesting that his conviction in count 1 be vacated and dismissed altogether, only that it be reduced from aggravated burglary to criminal trespass of a habitation to properly address his unlawful entry into this residence.
I mean, this case is so much like the Peters case that I'm familiar with. Can you distinguish that at all?
Yes, and obviously Mr. Dean cited it in his principal brief just to be candid with the court. But I think what makes his case different is that there was no proof of intoxication in the Peters case. We have that here.
But he also presented kind of a interesting, implausible story, like, oh, I thought I was being followed. Maybe that he was hallucinating or had some mental health issues. But again, the jury listened to all that and then made a credibility finding.
And I guess it just goes a little bit beyond the credibility finding where you're trying to determine whether someone's unusual behavior
What about
allows...
the fact that your client, when the officer talked to him, he denied he was on drugs?
So I think anybody who has any personal experience with someone who struggles with substance use disorder, deceit is a part of the disease. So I think the fact that...
So we can kind of overlook that lie, but...
Or just find that the lies and the deceit that Mr. Dean offered numerous times were just proof of his intoxication.
As opposed to him just trying to get out of responsibility for committing a burglary.
Correct, especially when you look at that interrogation video and see how Mr. Dean rambled in response to a lot of Officer Wright's questions. So, turning to the felon in possession of a firearm, the evidence is also insufficient to prove the culpable mental state required for that offense. And whether the state's argument is that of actual or constructive possession, the proof failed to show that Mr. Dean acted knowingly or intentionally. Of course, I'm going to go back to Mr. Dean's compromised mental capacity, as well as the fact that officers never saw Mr. Dean in possession of the firearm.
But he clearly had been in possession of the firearm because it had been moved from where the owner had it. It had been removed from the case and placed on the floor. So he was in possession of it.
So
It didn't move itself.
Correct. But I do want to push back on that a little bit, Judge Campbell, if I can. So how I understand actual possession under State v. Shaw is that someone has to have a knowing, direct physical control over an object. So if you have...
So holding it in your hand would not satisfy that?
I think that satisfies physical control over the object for a brief period in time, if I may recharacterize the facts here. If we have Mr. Dean rifling through the dresser, looking for clean clothes to wear, and he touched the gun while he was looking for those clothes and chose to discard it, we do have physical control over that object for a moment, but I don't think we have direct physical control over it. If anything, that's an indirect physical control of the object. And again, the mental state required for that offense is knowingly, and given the fact that Mr. Dean was suffering from auditory and visual hallucinations, I would just submit that we don't have proof that he knowingly had a direct physical control over.
So he didn't know he had the
firearm.
gun, but he did know he was getting clean clothes.
Yeah, I think so. Yeah, I think we could look at it like that. And then we also have to look at the fact that this was the homeowner's firearm, right? Mr. Dean didn't come into this home with a firearm. And the firearm was located in a dresser with several other firearms that was also in that dresser that were undisturbed. And this was a firearm in the home of at least 20 other firearms. So I just don't think these facts support actual or constructive possession just based on the case law, when you have to have a knowing, direct physical control over the object to establish actual possession. and you have to have the power and intention to exercise dominion and control over the object to have constructive possession. I just don't think we have that here, just simply because he chose to discard the weapon on the ground before hanging up the clothes that he chose to wear after his shower. So, if there are no further questions, this court should reduce Mr. Dean's aggravated burglary conviction to criminal trespass of a habitation and vacate his conviction for felon in possession of a firearm. Alternatively, this court should remand for a new sentencing hearing. Thank you.
General Ball?
Good morning. Ben Ball on behalf of the state. Obviously, I'm not Miss Redding. I'm filling in for her. She's going to be out of the office for a bit. Here, the evidence is sufficient to support the defendant's convictions for aggravated burglary and for the firearm conviction. For the aggravated burglary conviction, the state needed to show the defendant had entered the home and with the intent to commit theft. That he had entered the home is pretty uncontestable here. They found him naked in the shower when they came in. Notably, what they also found when they entered the home were sort of little piles of possessions of the Thomases who lived there, as if someone were collecting these possessions to take with them later. And it's important here that the defendant is found in the home. He hasn't left, so we can't look at what he takes with him. It's what he's planning to take with him. And of course, he does take something in the home. He does actually commit a theft there. He takes and eats a Pop-Tart, so at the very minimum we have that. So the question here sort of rises and falls on the defendant's claim about intoxication. And to be clear here, the only evidence of intoxication is some commentary by the officers the defendant's acting strangely. But we don't have our drugs themselves, and the defendant denies being on drugs. And of course, it's not simply enough that he may have taken drugs. It would have to overcome his mens rea. And here the defendant does sort of advance what may seem to be an outlandish story, but there's another way to look at this. He's caught, and he makes a bold claim that he is the homeowner. And he then identifies things around the house and tells them where they're going to be because he's had an inspection. This is a bold gambit that the jury can view two ways. Either it's a sign that he is somewhat rational, or that he's on drugs, and it's the jury's prerogative to resolve that question. I think supporting how the jury decided, when it becomes clear to the defendant that he can't support this claim that he is the homeowner, he quickly pivots and says, "Oh, but the homeowner let me in." So this assertion that the defendant was obviously on drugs and obviously couldn't form the requisite intent is not really borne out by the record. And it was the jury's prerogative here to determine that he did enter the home with the intent to steal these items. And that's supported by the little piles of items throughout the home that he intended to take later. As for the gun, he physically possesses the gun. He doesn't just discard it as he's digging through the drawer. He removes the gun from a zippered case. So he actually possesses the gun.
Well, maybe he did at one time. But I mean, when he's in the shower and it's far away from him in the shower, he doesn't really have access to it or control over it at that point. How do we reconcile that?
Not at that point, but we're looking here as from the standpoint of whether he possessed the gun as a felon. And at some point during this, he did. Now, he did not ultimately remove the gun from the house as far as a theft of the gun. But he did have possession of this gun. He did not just toss it from a drawer. He removed it from a zippered case and placed it somewhere else, which would appear to be to facilitate its later removal from the home as likely a valuable item that could be quickly turned to cash. But again, the defendant's essential defense of this is one of intoxication, and the same applies for this charge as for the others. Either simply something that the jury could resolve based on this evidence, and they determined that he was not so intoxicated as not to be able to formed the requisite intent. And that was the jury's prerogative. I believe the defendant has not addressed sentencing. We'll rely on our brief for the sentencing argument, unless there are any questions on any of the issues here. If not, ask this court to affirm the judgment of the trial court.
Thank you.
Thank you, Your Honors.
I guess I just want to address constructive possession a little bit, Judge Ayers, since you mentioned that. And I would just submit that the fact that the gun was located on the master bedroom floor and not in the drawer, along with the several other firearms that were there, that does not prove that Mr. Dean knowingly had the intention to exercise dominion and control over that single firearm, sufficient to convict him of felon in possession of that firearm. And I also just want to leave the panel with this, that the dispositive question here is not whether Mr. Dean was intoxicated, but what was his mental capacity? And did he have the mental capacity to act intentionally or knowingly when you look at his unusual behavior that multiple officers personally observed and testified to, and also that you could look at and look at for yourself. And I submit to you as a matter of law, his level of intoxication, coupled with his auditory and visual hallucinations, prevented him from forming the culpable mental state required for both of his offenses. Mr. Dean requests that this court reduce his conviction in count 1, criminal trespass of a habitation, and vacate his conviction for felon in possession of a firearm. Thank you.
Thank you both for your arguments and your well-written briefs. We appreciate those, and we will get an opinion out